Law Officer of National Women Commission, respected Registrar Sir, respected Dean, Professor Dr. Tapan Kumar Chandora, Associate Dean Dr. Monica Karuna, Director of IUMC'25, Professor Dr. Arun Kumar, all judges, faculty members, participants, and all dear students. I, Monica Kotyal, welcome you all to the valedictory ceremony of second edition IUMC' Mediation Competition 2025. It is said that art of mediation is not merely about resolving disputes. It is about fostering understanding, empathy, and building bridges where gaps once existed. Over the past days, we have witnessed the extraordinary power to communicate and collaboration showcased by some of the brightest minds. Today, we celebrate not just the winners, but every participant who dared to dream and worked hard to achieve. This year, we have received an incredible responses to the mediation competition. We have received registrations from numerous prestigious colleges across the country. However, due to cap of the number of participants, we limited registrations to 24 teams, ensuring a fair and focused competition. There are 24 slots we have filled by outstanding teams representing the following esteemed institutions: Rajiv Gandhi National Law University, Lloyd Law College, Maharashtra National Law University, Mumbai, Army Institute of Law, Mohali, National Law University, Nagpur, Lucknow University, Symbiosis Law School, Hyderabad, Uttaranchal University, then Fire University, Jaipur, Symbiosis Law School, Pune, University of Petroleum and Energy Studies, UPS, Dehradun, OP Jindal University, Jigyasa University, National Law University, Odisha, Krit P. Vinita School of Law, Mumbai, Delhi University, Maharashtra National Law University, Chhatrapati Shyamji Nagar. Their dedication, enthusiasm, and competitive spirits have truly brought this event to the light. I request my co-host to proceed with the event further. Thank you, ma'am. A very pleasant good afternoon to everyone. I am Hidachi Sharda, part of Team CR. Reaching this momentous occasion is the testament to the unwavering commitment of each and every participant, the invaluable guidance of our faculty advisors, the discerning judgment of our esteemed judges, the support of our partners, and the tireless efforts of our dedicated organizers. With great anticipation and profound gratitude, we now embark on the end of this enriching journey. Today, we will celebrate the mediation and negotiation skills of our participants, acknowledge the wisdom and support of our esteemed faculty members, express a sincere appreciation to everyone who has contributed to the resounding success of this event. To provide a brief overview of the event, the second edition of the IUMC' Mediation Competition 2025 witnessed enthusiastic participation for 24 registrations from across the nation. This intensive, 3-day intensive event commenced with the preliminary round on the 20th of March, followed by fiercely contested quarterfinals and semi-final rounds on the 29th of March, and today, on the 30th of March, we concluded with the final rounds. This competition has served as more than just a platform for showcasing the exceptional talents of our participants. It stands as a powerful testament to the hard work, perseverance, and unwavering dedication that each and every one of them has invested. With this, I request our Associate Dean Ma'am and Faculty Convener, Dr. Monica Karuna Ma'am, to deliver the welcome address.
Honored to have with us our distinguished chief guest, Honorable Justice Arjun Kumar Sikri, former judge of the Supreme Court of India, whose contributions to the legal field is an inspiration. We also extend our welcome to our guest of honor, Mr. Mohan Verma, Law Officer NCW, and Ms. Bhumika Sharma from NCW. I also would like to welcome our Vice Chancellor and our Registrar Sir, I also welcome the Dean of ICFI Law School, under whose leadership this event was organized. And I would also like to welcome all the participants who have made this event successful. My heartfelt thanks and gratitude to all those who acted as judges in this event and those judges of the prelims, semi-finals have been with us throughout the event and they have worked hard in order to make this a learning process. I am thankful to the judges of the final round. We have with us Mr. Chakrapani Mishra, Senior Partner at Khaitan & Co. Mr. Rohit Jolly, Partner, Hammurabi and Solomon. We have with us Mr. Param Vamra, who is the founding partner of Mediate Group. We also have with us Mr. Subhash Butaria, founder and principal at Law SB. We also have with us Dr. Madhuri Irene, who was judging the final round. I am thankful and I welcome all of you to this valedictory session, and we hope that the event has shown the students how mediation is going to be one of the important pillars of delivery of the justice system. So thank you and welcome to all.
Thank you for the heartfelt welcome, ma'am. Now, I would like to request our Dean, sir, Professor Dr. Raman Kumar Chandula, to address the audience.
Good afternoon to everyone present out here. I welcome you all in this momentous occasion of our valedictory ceremony of the second edition of the ICFI mediation competition. And I would like to greet our renowned chief guest for the day, Honorable Justice Mr. Arjun Kumar Sikri, retired Justice of the Honorable Supreme Court of India. Sir, a very happy welcome to you. And also thank you for taking out time for us. It is a deep honor for us to find you amongst us, and your wisdomful words will definitely guide us and be motivational factor for our future endeavors also. I also like to welcome and thank Mr. Manmohan Verma, who is the guest of the honor, who is the law officer at National Commission for Women, who is present amongst us. So welcome, and again, thank you for being here. I also like to welcome Mr. Chakrapani Mishra, Senior Partner at Khaitan & Company, Mr. Rohit Jolly, Partner at Hammurabi and Solomon, Mr. Subhash Butaria, Founder and Principal at Law SB, and Mr. Param Vamra, Founder Partner at Mediate Guru, who were also incidentally the judge for the day for judging our final rounds. And of course, our reverend and our extreme motivational factor, our Honorable Vice Chancellor, Professor Dr. Ramkaran Singh Ji, and the Registrar of the University, Dr. R.C. Ramola Ji, who have always been a constant support and guiding force in organizing such events. All the faculties out there, all the students, all the committee members, again, I would say welcome as well as thank you for organizing such a successful competition which lasted for 3 days. And all the participants, I have been informed that the sessions were quite intense, intellectually intense, and the approach was quite professional. So that is actually the objective of the competition, to give the exposure, to give that kind of experience, along with the learning notes which one should take alongside the competition. I also witnessed that it was not just a competition, but a remarkable display of skill, empathy, and pursuit for peaceful resolutions. Through this competition, everybody sought and tried to take experiences and observations. This competition is a result of the hard work of all the faculty conveners of Center of Excellence of the Ultimate Dispute Resolution and the students also who have put their blood and sweat for making this competition a success. We should all remember that mediation is not just a skill, it's a philosophy, it's a way of life. I want to reiterate my sincere congratulations to all the participants again. You have made us proud. May your journey ahead be filled with success and you may continue to be champions of peace and understanding. Thank you.
Thank you, sir, for your insightful words. I would not now request our Honorable Registrar to join with us in virtual mode, Professor Dr. R.C. Rahula, to address the audience.
Very good afternoon. I'm able to, are you able to hear me?
With our Honorable Registrar to join with us.
Are you able to hear me? Hello? Very good afternoon. Uh,
At least I can hear you. I don't know.
okay, sir. Very good afternoon to,
Are you able to hear me?
Yes, sir. Yes, sir.
very good afternoon. Hello. Good afternoon to all the esteemed guests who are present here and all the faculty members, Honorable Vice Chancellor, sir, senior professors, participants. Uh, so it's a very happy moment that we have come to the end of the valedictory function um, of our second mediation competition. Hello.
Yes, please go on. Please go on.
Yeah. Okay. So first of all, I congratulate all the participants who have won these competitions in various activities and uh, various activities and they I also congratulate all uh, the organizers who have successfully completed this competition and this is this was a big event, 3-day event. Last time we have organized and this is the second time and the team members who have participated from the across India, his number has increased. So big achievement for our law school that they have uh, organized this event very nicely and the successful of this event is due to the participants who have come all the way and I hope that this 3-day competition will be very helpful in the learning process. They have developed these skills. They know what is the mediation way, how to make justice, how to develop the solution for any issues, how to settle down the issues. So, with these words, I congratulate the organizers who have organized this event from the law, Dr. Monica uh, and Dr. Sunil, and all the volunteer students who have volunteers for this event, and particularly the leaders, Dr. Chandula, the Dean ILS, Associate Dean Dr. Monica. Uh, with these words, once again, I congratulate and my best wishes to all the participants. Thank you very much.
governance, and constitutional issues. I now respectfully request Honorable Justice Ajit Kumar Sikri to kindly address the audience.
Thank you very much, and good afternoon to all of you. I was wishing to be present in person and be there with you people to address their and meet all of you also because of various reasons. And if I may say at the outset, which is what this competition achieves is that the team of mediators which you are creating, they are the peacemakers of our society and they are the future of the society. That is the fundamental message which I want to give. In fact, if we see here, uh, this section 89 was introduced in our Code of Civil Procedure by amendment in the year 2002. And mediation as one of the processes for, or one of the mechanism for settling the disputes. Before that, obviously, nobody knew what mediation is. Of course, we keep saying that look, mediation in this country has thrived for centuries in the form of Panchayat Raj, which we used to have. They would try to settle the disputes amicably. And we even take the example of Krishna during Mahabharat, Lord Krishna going to Kauravas and trying to settle the matter, though that failed. So mediation is not unknown insofar as Indian civilization is concerned. But the mediation in this form, the present form, the way it is practiced, of course, it was not known here. Notwithstanding the fact that we had Lok Adalats also, which was introduced and by passing the Legal Services Authority Act way back in 1986, and they have proved to be great success. But even that is not what mediation is. Why I say so? This, as far as the audience here is concerned, particularly the students who have participated in this mediation competition, they now know very well what is the purpose of mediation. But if I may paraphrase, when Section 89 was introduced, the main purpose, and that is what was, at least I won't say main purpose, but perception, I would say, and was that look, our courts are highly, I mean, there are number of cases pending in the Indian courts. Dockets are overflowing, they are overburdened. So we have to ease the burden of the courts. And one way is, apart from arbitration, that we should introduce mediation also. And Section 89 was what we call court annex mediation, where the case is pending in the the judges may send that case to the mediator for settlement. So in a way, that would reduce the burden of the court system. And we knew it, it was told, and we read it also that it has become, and it had at that time, by that time, I would say, had become a very successful uh, process of settling the disputes in United States. As of now, and at that time also, and today as well, 93-94% cases in US are settled through mediation. It's not only court annex mediation. There it has gone far ahead, where even before going to the court, the parties themselves agree that let us go and get it settled through mediation. There are mediators who are well-known mediators, well-recognized mediators, proven mediators. So parties will say that, look, let us go to them and settle. most of the time disputes are settled through those mediators in mediations, and don't even land up in the court in the first instance. Even after the cases which are filed in the court, like our section 89, court, when we say court annexed mediation, the cases which are pending in the court, they are sent for mediation in United States, and therefore ultimately the cases which go on for trial in US is hardly 5 to 6%. So in that manner, it is, I mean, we hope that it will facilitate reducing the burden of the courts in a big way. But what I feel is that is that may be one of the purposes to achieve this kind of objective, that reduce the burden so that the courts are not overburdened and they are able to devote to those cases which are more important. And because we know that every case cannot be settled through mediation or even through arbitration, there are certain cases which have to go for litigation in the court. But what I am saying is, more importantly, more than, and that is my hypothesis that I have always felt, that more important purpose of mediation is access to justice. The kind of justice which mediation can achieve, no other means of settling the disputes, whether it be courts. I have been a judge for 20 years in the court. I know, not that courts do not do justice. We try to do bring about the just resolution of disputes and the best manner in which these can be settled. But in spite of best efforts, there are many, many circumstances, there are many, many situations where court may not be able to deliver, as I am saying in inverted commas, what we say justice. That is because of the fact that the one, yes, delays, and we say delay, it's a famous saying, justice delayed is justice denied. So if the case is settled in 15 years, 20 years, of course, even if the resolution was more appropriate and very good decision which was given, which is given by the court ultimately, but it may not be of that use to that particular party. But another important feature, or we would say weakness, of our litigating system is, and which is in the arbitration also, is the adversarial system. We are in adversarial system, and in an adversarial system, many times we are not able to achieve the just and best results. There are two parties, they would come to the court, both the parties will have their cases, they will, and what this adversarial system looks into, it goes into the past. Because if I come to this, suppose it's I give you an example, it's a matrimonial case. Wife files a case against the husband on the ground of cruelty, that she has been ill-treated, maltreated by her husband. And these were the instances, these were the time to time she was treated like that. So wife now comes to the court and files a case for divorce on that ground. What court will do in that case? Court will only go into this past on the allegations of that wife which she has made, that this is what had happened, whether that was right, that was wrong. So court looks into the past. Yes, here in a case like this, husband would naturally say, sorry, I did not do that. Or may give his own justification on those so-called acts of cruelty, whether they amount to cruelty at all or not. So now the judge is deciding first on facts, whether wife who has alleged these 5 or 10 instances, whether she is right or she is wrong. Maybe she has been able to prove 5 out of it, 7 out of it and all. And the second is whether these constitute cruelty or not. Now, the two persons who have come and they have taken their positions, and the court is only deciding who is right, who is wrong, and whether these acts which are proved constitute that cruelty or not. So in adversarial system, all that comes before the court is taken into consideration, because courts do not have the what we call inquisitorial power that to go of their own. They will only go on the basis of the evidence which is produced before the court, not beyond that. That is one aspect. And other, as I said, that they will only decide, they'll go into the past and on the basis of that decide who was right, who was wrong, and the person who was wronged, the remedy should be provided to that. But mediation goes much beyond that. In mediation, what I said here was that the two parties take position. In mediation, yes, we go into the past while doing that exercise. We also see who was right, who was wrong, but instead of, and it is not to be decided because mediator won't decide that, but take into consideration this, what his or her endeavor would be to look into the interest of the party, what is in the interest of the party, not what the positions which they have taken. So in a case, the example which I have given, whether it is possible if husband had committed certain acts that he can mend himself. It is possible whether the relationship can still be mended and restored, but because there may be children, there may be other factors. So what are the interests of both the parties? And wife may not be doing, say, any job or anything, whether she'll be in a position to survive herself if the divorce is granted. So those aspects, their future and their interest will be discussed. And on that basis, now, unlike the court system, in mediation, it's not only whether one is right or the other is right and what should be done, divorce should be granted or not. No, there would be various possibilities in dialogue, in negotiations, there are various possibilities through which there may be 5, 7, 10 solutions which are placed before the parties, and parties, if they agree, may agree on one possible which is best suited to them. And if it results in settlement, that is why we call it is win-win position. Because in mediation, from positions, we go to interest of the parties. I don't know whether any of those students who have taken this, training in mediation or not, who participated in the competition. And but let me tell you, there's one very interesting example which is always cited. When I took training as mediator, when I was still a High Court judge and mediation movement had just started. Of course, I was from the very beginning when in Delhi High Court the mediation center was set up, and I was made a member of that committee, overseeing committee which of the High Court judges. And when we had to train the mediators also at that time I'm talking about 2005 and 6. So when we had to train the mediators, we invited trainers from outside and those who gave training to the lawyers to become good mediators. So I myself, three judges who always participated in those trainings. So I have first-hand experience of these trainings, and I must have attended 7, 8, or 10 such training programs in those times. But what I'm trying is when one very good example is given that there's an orange mother has and she has two daughters. She wants to give this orange, so she thinks that I should give half and half to both, obviously. And this is what happens in court. And this is, one will perceive it's a good justice, equitable. Two daughters, she is giving half and half. But both are not happy. Why? One wanted full orange. And she said, how can I give you full orange? After all, I have my other daughter also. I have to give it to her also. Without realizing what was the interest of the second daughter. She was not interested in orange. She wanted peel because she wanted it like a beauty treatment. She would be able to facial. She would be able to do it. So she wanted the peel of the orange, whereas the other girl wanted. So mediator sees these interests of the parties, and then come to the solution. Had mediator taken that, mother taken that into consideration and asked what you want, it would have been a very simple thing. One is given the peel and other is given the orange. That is what mediation achieves. I tell you, very interesting thing. And I am giving you now the live examples, actually what happened. One couple who had married and were in marriage for only 2.5 years could not go on well with each other, temperamental differences or something, no cruelty, etc. But many times in young couples, we have seen nowadays temperamental differences. And they took divorce by mutual consent. But the problem was stuck at the alimony or the maintenance which was to be paid to the wife. That matter was still in the court, and court sends that matter for mediation. So for mediator, as per the court is concerned, it was sent to decide how much compensation, how much maintenance per month should be paid. You know what was the settlement? Nobody can even think of. Mediator saw that it was only a temperamental issue. It was a love marriage. They loved each other immensely. They had relationship for 5-6 years before they got married. So a lady mediator went into all this, tried to tell them that look, these temperament, and the parties got remarried. Where the dispute was that how much maintenance should be paid. Parties got remarried. I give you another very interesting example which we had in. I'm just wanting to say that how the mediation does more justice than what the court cannot do. In a case like this, court would have only settled the mediation, the maintenance, and the parties had remained separated throughout, had started their different lives, whatever would have happened. But it has more than 10 years have passed and the couple is still together and they have their now 2 children also. Another example, very interesting, those who have studied this trademark intellectual property act. One very famous international brand in garments. I give you an example, just hypothetical. I mean, the name I'm giving hypothetical, the incident or the anecdote is real. Was say Burberry. So there was now Burberry we know is famous throughout the world. And here what happened that one in Ludhiana, you know, there are many these garment factories, etc. So one person was, he had imported machinery, very high class, very good machinery. But then he thought that if I fabricate the garments and sell in my name, I may have to create, it may take years together to, market that name and to create a goodwill. So why not? He started manufacturing the garment and started selling with the label of Burberry, which happens. It is in our, we call it counterfeit. And it is a violation of the trademark of Burberry's. So Burberry files a suit for injunction that they should be restrained from selling. A very clear case, shut and iron case where it had to be given. But what happens? In that case, the judge sends for case for mediation. In mediation, now if the injunction is given, naturally, which was to be given in a court in a case like this, that either this person would have, started manufacturing with his own name and selling, but sales would have dropped dramatically because as Burberry goods were selling, he had to then shut his factory or maybe reduce his labor, etc. But he had taken loan of 50-60 crores and it would have become difficult to pay off those loans. But what mediator does? He just called them to party. You know, these, as I'm saying, Burberry, not that they have their own factories. They normally get it fabricated from other persons. They, yes, they will have the quality specification that it has to be in this particular manner, it has to be stitched, and this kind of cloth, etc. Sometimes they give their cloth themselves so that the quality is maintained. So mediator, to cut short the story, mediator gets it settled where he convinces these Burberrys that when you are getting it from outside, why can't you get it manufactured from this very factory? So they become partners, where now Burberry is placing them the orders, and that person is now supplying to Burberry's instead of selling it in the market as a counterfeit product. Now, this can be achieved only in mediation, and there could not have been such a result. So therefore, what I say is that as I said, that it is the, in many situations, best form of access to justice. And I have number of such examples. The time doesn't permit, I would not be able to give. And as everybody knows, it brings about win-win situations. And what it does, I say another thing, that it goes into the causes of the disputes and tries to resolve. It goes into the facts why the disputes arise at all in the first instance. Psychology of the people, and why. And it is normally what happens, as I've said, when the parties take their positions. In a court, or in any case, it is I versus you. I would I think that I am right. Other parties thinking he or she is right. Both are holding on to their position, and since both of us think that we are right, but mediation always recognizes there are three types of the stories, namely yours, mine, and third is truth. What is truth? Because many times we are hazy. We don't even ourselves see what is correct, what is not. If I give you the example of Mahabharata, in the battlefield, when Krishna is there preaching Arjuna, when the Arjun doesn't want to fight. He says, I don't want to fight. They are all my brothers and my uncles, etc. in the battlefield. I don't want to kill them. Now, you know it that Dhritarashtra was from his palace, was watching what was happening. He was not watching, he was a blind person, but Sanjay was narrating what was happening. Sanjay had that far sight, he could see, and he was narrating. Now, Arjuna is the here, as we call it in this example, that Arjuna is the seeker, but Krishna is a source. Krishna is the source, Arjuna is the seeker, Sanjay is only narrator. He is not bothering what is happening is right or wrong, he is just narrating. Dhritarashtra is a person who is in a way seeing it in very myopic view. It is giving whatever is said in favor of Kaurava. When Arjun says, I don't want to fight, he's very happy because it is going in favor of Kaurava. He starts blaming Krishna when Krishna says that no, you have to fight. So therefore he is only looking it from his angle. So every person this story tells look into from different angle everything. Now in this mediation, this is my again hypothesis, is a two-level step. First, making everybody realize that look, what you are saying may not be entirely correct. There may be something else also. So why not try to see the other side as well instead of what you are seeing? And therefore, once they realize it, then the second step in this is that from I versus you, it is we, both of us, coming on the negotiating table, sitting along with mediation, where the all this is discussed and these kinds of results can be brought. So this is what mediation is. And if I may not take more time, because this is one thing where if you give me 2 hours, I can give a lecture for 2 hours. But what I would say is 3 or 4 things, 2 or 3 I have already said, that Number one, it reduces the burden of the court. In that sense, mediation's miracle is it is capable of saving judicial system, which is crumbling under pressures. It is capable of saving arbitration system, which has its own weaknesses and faults which you are finding, because now with the introduction of mediation into the arbitration process also, what we call MEDAD or RMED. And there are at least 5 or 6 very interesting example anecdotes which I could give, but for I mean, the time is short, I would not be able to give. Other is I have said that this is, I mean, best form of access to justice, as it brings a win-win situation, and in the process, it brings peace in the society. Therefore, I always say mediators are peacemakers. I'm so happy that from moot court competitions, of course, they would remain, the moot courts, etc. We are now having these mediation competitions also, and training students from this at this stage itself. Yes. And I would say to all, and first let me congratulate therefore IFCAI for holding this second edition of this competition. And I would say all the students who are who have participated, that you become future mediators. Mediation is going to have its own now, like litigation lawyers, they will be mediator lawyers, as mediators, as persons appearing before mediation, and it will be a full-fledged profession in time to come. And instead of alternate dispute resolution, I would call mediation as appropriate dispute resolution mechanism. So therefore, I congratulate IFCAI, and I congratulate all those who have participated in this moot court competition. And I would say, Lage raho Munna Bhai, you are on a noble mission of peacemaking. Thank you very much.
Of why mediation is important and how the future will be saved through mediation. So we are extremely honored to have had you here and to speak to us with clarity which the students have taken note of. And I'm sure that in the coming days, we are going to have some very effective mediating professionals that will pass out from not only IFCAI University, but also the participants who have come here from Pan India are motivated to do even better, looking at the ambit and scope of mediation. Sir, we would have loved to have you here with us, and I'm sure that your blessings would motivate us or the faculties and even the students. But we've had the privilege of seeing you and hearing you, so it's been a blessing. Thank you very much for your kind words and for the motivation to the students. Thank you, sir. It was a privilege to listen to you. Thank you.
Now, I would like to
Just
invite.
before that, I'll like to take leave because I'm a little late. I had to go somewhere, so it's already 2 o'clock. So please, I will have to leave now. Thank you.
Thank you, sir. Thank you for your time. Thank you once again. On behalf of IUMC University.
Now, I would like to request our guest of honor for the day, that is Mr. Manmohan Verma, Law Officer, National Commission for Women. In his significant role, he has actively involved in legal matters pertaining to women's rights and various issues addressed by the Commission. Now, I would request our guest of honor, Mr. Manmohan Verma, to share his thoughts with the audience.
Respected Registrar Professor R.C. Revola, Dean of IFCAI Law School, Mr. Tapal Kumar Chandola, our our chief guest who recently left, Honorable Justice Arjun Kumar Sikri, and all the participants present here. I'm really thankful to all of you that you gave this opportunity to National Commission for Women to have a partnership with you for this mediation competition. And we are very delighted to be here after knowing the fact that you had a very good mediation competition recently. Justice CP was recently telling about the past of mediation, that it is way back in the era of Mahabharata. But I would say that mediation is something that we are living with them. When we are child, we always approach for mediation with our parents, with our friends. When we move on, for certain things, we go for mediation with some other people in family. So mediation is something which we are already living. It has been institutionalized by the courts, as Justice Sikri was saying about the section 89. It was institutionalized considering the importance and to reduce the burden over the courts. One of the important factor of the mediation is the mediator. And what is the importance of a good mediator? The good mediator must be a neutral person. As Justice Sikri was saying, the mediation in the court of Dhritarashtra was failed. Why? Because the Kauravas was not having faith on Krishna. So it is also very important that both the parties to mediation must have faith in the mediator and they must be willing for the mediation. You cannot force upon anyone about the mediation process, though they might be coming to you for mediation, but they always keep their interest related to the dispute. See, we people are having very short memory regarding the issues, and sometimes we forget the reason for the dispute, but we do not want to lose our interest. Considering the important role of the mediators, like that mediator must be neutral, it is also important to understand the situation of both the parties. When the mediator is able to understand the situation of the parties and why the dispute occurred, and what could be the possible solution for any dispute resolution, then only effective mediation occurs. Since we are from National Commission for Women, I have to tell you sadly that most of the time, women is not the person who is getting a good result out of the mediation. Though it is the intention of the mediation process that some win-win situation should be arrived, but as per the figures, most of the time, in any dispute, the woman is the sufferer. Especially in case of property dispute, it is expected that the woman should understand about the family situation and she should leave her interest to preserve the family. And since the male are considered as the breadwinner, generally in the mediation process, it is considered that the property should be given more in the favor of male person so that the interest should be protected, and this is something which I am talking about on the basis of facts and figures. Though the intention of the mediation is that it should be equal for both the parties, but this is something the facts what we got to know. See, we also get so many complaints in the National Commission of Women about certain issues like domestic issues, family issues, also some of the property issues. And these some of the things are, we also go for the mediation process in our commission. We also conduct Johnson wise for this purpose. And the entire process what we follow is to avoid the legal process, which is very suffering for both the parties, not just for the time, also the money. To cut short this, we also promote the mediation process. But still there are certain stereotypes which are preventing for effective mediation, especially for the gender stereotypes. Gender stereotypes is something like which is unconscious bias. You are not, you do not want to do these kind of bias thing, but the prevailing situation of the society and the situation of the families in the society, it is very difficult to, keep yourself away from these kind of stereotypes. For example, let me just ask all of you, how many of you know the name of your grandfather and the name of great grandfather? So many people know the name of your great grandfather. And what about the great great grandfather? Nobody. Okay. So when I was asking you about the name of your grandfather, how many of you were thinking the name of your mother's father? None of you. So this is the gender stereotype. That whenever we are talking about the grandfather, generally the name of our father's father come in our mind. So if you Google it, you will get to know that grandfather is for either of the parents, father of either of your parents. But this is something the unconscious bias. This is also happening with the mediators. Though they consider themselves as gender neutral, but due to these certain things, these certain stereotypes, they ought to follow the same system which is prevailing in the society. So, with this, I wish to all of you, the future mediators, to not have any gender stereotype and try to be more gender neutral. I wish many of you must be thinking that you are gender neutral, but that is also, very difficult to understand why we call ourselves gender neutral. Because if you are following some of these kind of stereotypes, then you are not gender neutral. So to have a good mediation process, you also need to understand, and you also have to forget all these kind of unconscious bias. So with this, I just congratulate all of you. Thank you, ICFI University, for giving us this opportunity, and I wish you great success. Thank you.
Thank you, sir. I request you to be on stage. And I request Dr. Walter Kurula, Associate Dean Sir, to felicitate Arun Sir, our Director of IQAC, to felicitate our guest of honor.
And thank you, Mr. Manmohan, for this. And I hope and wish that National Commission he has suggested will promote our events in future. And he's also kind enough to say that they can financially also support our events. So thank you very much. Thank you.
Let's Ms. Bhavika to join us on stage. From National Commission. Kindly remain with us on the stage as we felicitate our esteemed judge of the final round, as most of the judges has gone. So I request Dr. Madhuri Giri, Associate Professor. Ma'am, kindly remain with us on the stage as we have now arrived at the much awaited moment of recognizing and celebrating the exceptional talent displayed throughout this. The best mediator from the preliminary round is TC18, winning the cash prize of Best mediating pair from the preliminary round is TC11 from the Nurses Boston Clinic. The best mediator winning a prize of rupees 10,000, a 25% discount on course of their choice on Manupatra, and Law of Lupus coupon code worth 2,800, worth 7,700 on 8 area courses is TC. Does anyone have any guesses? The best mediator is TC13 and then
Any volunteer? No. Right, you go. Yes. No, you see volunteer.
The runner-up mediator is TC23, ILC Faculty of Law, winning a prize of 10,000. Law of Lupus status worth 2,800 on 1 year basis. For winning mediating pair, winning a prize of rupees 20,000, 100% discount on a course of their choice on Manupatra. Does anyone has any guess on the TCs? Winning today.
Is it beautiful? Must go with the runner.
So winning TC is TC24.
24. लगाओ फुल स्क्रीन में, ये लगाओ, पिन दिस। Close, close.
When it price of rupees 50,000, a 50% discount on the whole of it also money partner is TC04 Army Institute of Law, Mohali.
Oh.
The best mediator from the preliminary round, winning a prize of rupees 4,000, is TC18 from National Law University.
रुकना नहीं है, एक बार।
Best mediating pair from the preliminary round, winning a cash prize of rupees 6,000, is TC11 from Symbiosis Law School.
Shift to back one, back one, पीछे वाला, इसको बंद कर दे।
To all the participants, I extend my heartfelt congratulations. Each one of you have demonstrated remarkable efforts and skills. The experience and knowledge you have gained through this competition are undoubtedly recognized. We now move toward the concluding remarks. I would now like to invite Mr. Prabhakar Das, faculty member Seattle, and placement manager to deliver the vote of thanks.
Thank you, Hitachi. Greetings to our honorable chief guests, respected dignitaries, faculties, and participants. As we gather for the valedictory ceremony, I would like to take a moment to acknowledge with appreciation their collective efforts driven by the spirits of cooperation and mutual respect, which have made this competition an unforgettable experience. It is said that behind every successful man, there is a woman. I would like to add that behind every successful event, there is a team of women. Starting from the associate dean, Dr. Monica Farola madam, to theatral co-convener Monica Kochar ma'am, to faculty Riya Juneja ma'am. My students, Shreya Singh, Shraddha, Kanak, Hitakshi and others. That will be injustice to my boys if I miss to appreciate them like Sahil, Vikranta Alavat, Arnav Tripathi, Milo, and others. I'm so sorry if I call you to follow me today. To our eminent chief guest, Honorable Mr. Justice Arjun Kumar Sikri of the Supreme Court of India, Mr. Manmohan Verma, Law Office of National Commission for Women, New Delhi, we extend our heartfelt gratitude for your presence in the occasion. Your presence elevated the standard of our event, and your words of wisdom and encouragement have enlightened us all. To our distinguished judges, Mr. Sanjeev Nirvani, Mr. Shreyas Tripathi, Mrs. Krithi Agarwal, Ms. Ayushi Sharma, Mr. Aditya Aryan, Ms. Janvi Vashish, Ms. Akshita Salampuria, Mr. Puneet Jain, Ms. Hamda Yafreen, Mr. Rishabh Yadav, Ms. Yamini Bish, Mr. Subhash Kutoria, Mr. Amit Kowar, Mr. Mr. Param Brahma, Mr. Chakrapani Mishra, Mr. Rohit Jolly, I applaud your efforts and contributions. Your expertise, guidance, and feedback have helped shape the future of mediators. Your support added credibility to our events. Special thanks to our faculty judges, starting from Dr. Madhuri Ayale ma'am, to Dr. Monica Corona ma'am, Dr. Chalish Mishra, Dr. Vivek Kumar, Mr. Aditya Tomar, my friend, Miss Monica Kochial, Mr. Divesh Chauhan, Mr. Deepak Kumar Gupta, Mr. Parth Upadhyay, Miss Deekshita Priyadashi, Miss Madhuri Kundi, Miss Megha Chandok, Mr. Gaurav Yadav, Miss Priya Kumari, and Miss Surabhi Goyal. I would like to express the gratitude to our esteemed dignitaries, including the Honorable Vice Chancellor of the University, to Registrar, my favorite, popular, enthusiastic Dean of ICFI Law School, Professor Dr. Tapan Kumar Chandra, sir, co-convener of the event, Monica Bhagan, the faculty members, for your valuable contributions, unwavering support, and encouragement to our events. To all our participants, very much thankful. I am very much thankful to our participants. Your participation is the key to make this event successful. I offer my appreciation for your enthusiastic participation and passion for mediation. I must say that winning and losing are the part of the game, but rather, this should not be impact your performance in future events. Rather, the experience and knowledge gained. I would like to thank the support staff, the technical team. आपके support के बिना ये संभव नहीं हो पाता. Special thanks to Riya Juneja ma'am for the entire stage decoration and whenever we asked her and she was ready to help our students. Lastly, I extend my sincere thanks to our organizing committee and everyone else who has put in tireless efforts to make this event a grand success. Thank you once again.
Thank you, sir, for your vote of thanks. I would now request our associate dean to officially declare the event as closed.
With a word of thanks to everyone who's made this event possible and successful. Thank you, everyone. I close the event closed. I declare the event closed. Thank you.
As we draw the curtains of the successful valedictory ceremony, I would request everyone to kindly remain standing until the dignitaries have left the auditorium.